versus Man Davis.
Right away, you can feel the temperature in this courtroom climbing. Judge Simpson is not easing anybody into the day here. That opening tone tells you everything. Patience is already running low. Excuses are going to be tested hard, and every attorney walking up to that podium knows they'd better be prepared. These early moments matter because judges set the emotional rhythm of the courtroom fast. If the court senses delays, sloppy preparation, missing witnesses, or weak explanations, the mood can shift from routine to ruthless in seconds. And that's exactly what we're watching unfold here. What makes these hearings fascinating is that they look procedural on the surface, but underneath, every tiny detail affects someone's freedom. Bond decisions, phone privileges, missed court dates, witness availability, these are not small issues. One bad answer can completely change the outcome of the day. And viewers, let me ask you this. When a judge starts court already sounding frustrated, do you think defendants get treated more harshly, or is it simply the court demanding accountability? Because today, that tension is hanging over every single case coming through this courtroom.
Lucas on behalf of Man David.
All right, what are we doing?
Your Honor, at this time, we'd like to set this for a preliminary exam.
Discovery complete?
To my knowledge, yes, Your Honor.
Was this wasn't one of the ones that was Washington, was it? I can address.
People would have their witnesses available the 27th?
Yeah.
Seriously, so. Preliminary examination will be set February 27th, 2024, 9 a.m. That is before Judge Barr. Bond will continue.
I do
Yes.
have one matter
Yes.
relevant for bond. We would be requesting that the defendant's jail phone privileges be revoked at this time. I have notes from interns showing that the defendant has been contacting the victim personally via jail calls. He's also been contacting other individuals. And other individuals have been contacting the victim by calling and leaving messages and asking her not to come to court and to accept the defendant's calls from jail. My victim advocate tallied that he tried to call the victim 8 times between February 8th and February 12th. And the reason we're not just asking for her phone number to be blocked is because he is relying on other individuals in order to contact the victim as well.
Your Honor, I have not heard any of these phone calls. She did allow me the courtesy of telling me that yesterday about these phone calls, but I haven't heard them. So without having the evidence in front of me, it's hard for me to argue about trying to have them revoked, but I just ask that you would allow them to stay in place. I have instructed him not to have any conversations with anybody.
This is where the situation suddenly gets serious. Prosecutors are alleging that the defendant kept trying to contact the victim from jail, not just directly, but allegedly through other people as well. In court, that is a massive red flag. Judges take witness intimidation and indirect contact extremely seriously because once the court believes someone may be interfering with a victim or the process itself, privileges can disappear immediately. Now listen carefully to the defense attorney here. He's trying to slow the momentum down by pointing out something important. He personally hasn't heard the recordings yet. That's actually a smart legal move. He's basically saying, hold on, we need actual evidence before punishment escalates. But the problem is, Judge Simpson clearly isn't interested in waiting around if there's even a possibility the victim is being pressured. And this is where courtroom reality hits hard. A defendant can lose privileges before a full evidentiary fight even happens if the judge believes safety or court integrity could be at risk. Seconds later, the hammer comes down, phone privileges revoked pending a hearing. Clean, fast, decisive. Judge Simpson wastes absolutely no time establishing control over this courtroom.
Defendant's phone privileges are hereby revoked pending a hearing. You can have that hearing or try to set that hearing before Judge Barr at the time of the preliminary examination, but as of this point, his phone privileges are revoked. Thank you. Court calls case People versus Gerald Turner. Court calls case People versus Christopher Gustafson.
And good morning, Your Honor. One more time, Robert Elman, here with and on behalf of Mr. Gustafson.
Your name, sir?
Christopher James Gustafson.
Thank you. What are we doing?
Your Honor, at this time, I do believe discovery is complete, and I'd like to set this matter for a preliminary examination.
People would have their witnesses available to 27.
I believe so.
Preliminary examination, February 27, 2024, 9 a.m. That is before Judge Washington.
Yeah, I'm gonna do that next.
Bond will continue.
Your Honor, may I address bond briefly?
May.
Mr. Gustafson is currently in custody right now for failure to appear at our last court date. I believe bond is set at 10,000, 10%. He does have another pending case where he is released on bond on a GPS tether. I believe that that tether would handle any concerns that we would have about Mr. Gustafson appearing. So, and also, Your Honor, the day before court, Mr. Gustafson's grandmother, unfortunately became very ill and passed away. His sister was his ride to court that day, and unfortunately, she, instead of taking.
How did he come back into custody?
My sister, oh, sorry, can I talk?
Go ahead.
Okay, yeah, my sister called them to come pick me up because I had a warrant.
This exchange is unbelievably awkward, and you can actually hear the defense strategy falling apart in real time. The attorney is trying to frame the missed court appearance as a family tragedy grandmother passes away, transportation issues, emotional chaos, and honestly, that can sometimes generate sympathy from the court. But then Judge Simpson starts digging into one key detail. How exactly did this defendant end up back in custody? And the answer completely changes the atmosphere. Instead of voluntarily surrendering, the defendant admits his sister called authorities to pick him up because there was a warrant. That distinction matters a lot. Courts usually view self-surrender as accountability. Getting turned in by family? That lands very differently. You can practically hear Judge Simpson locking onto that inconsistency immediately. What also hurts here is timing. The defense keeps emphasizing the GPS tether and support system, but the judge is focused on behavior, not promises. The court already feels the defendant failed once, and now every explanation sounds reactive instead of responsible. This is one of those classic courtroom moments where a case goes sideways, not because of one dramatic explosion, but because small details stop adding up under pressure.
But
So they,
no more new charges.
so it's
So he didn't turn himself in.
No.
he,
Okay, that answers it. You got anything else to say?
Your Honor, as I was saying, and I understand, but his sister was his ride to court, and she,
Same sister that turned him in?
yes.
Yeah.
Oh, things went south.
Well,
Go ahead.
so I was needing a place to stay because recently. Okay.
So, yeah, I don't want you to say too much, okay?
Okay.
So, Your Honor, again, he is on a GPS tether already for another case, and I think that would ensure his ability to get to court. And as you've just heard, his sister seems very invested in making sure that he now takes care of this as well. So I would ask that he either have a bond reduction or you release him on a PR bond with a tether.
He failed to show up for his hearing on the 25th. So I don't need a response from the people. He didn't turn himself in. So motion for bond reduction is denied. Bond will continue. Thank you.
Thank you, Your Honor. Have a great day, Your Honor.
You do the same, sir. Court calls the case People versus Ames Bishop. Versus, is it Zakila Hill Witset?
We're ready in this matter.
Good morning, Your Honor. Robert J. Kilwald, Your Honor. I'm on case 24F1008.
Good morning. I'm gonna assume the box of Valentine's Day chocolates I sent you didn't arrive.
They did not, they did not.
Anyway,
Out of love in this court this morning, Judge.
one Brown deputy chief public defender appearing with
We just
Hill
don't
with
set
them.
for exam. On these cases,
Just go ahead and put your name.
Actually, they did arrive.
tell the judge your name.
Kyla Hill, what's that?
Alan ate him.
Huh?
Go ahead.
Let's adjourn and I'll come and talk to you. Okay.
Mr. Ballinger, he's sick, something like that. Mr. J, Mr. Ballinger.
No, I'll wait.
Judge, in these matters, we're going to set this for exam, and we may have a resolution prior to that. We'll notify the prosecutor, but as of today, we're setting these matters for exam.
Is all discovery complete?
As far as we
Yes,
know.
Your Honor.
You can tell this courtroom has shifted into controlled chaos. There's joking about Valentine's chocolates one second, then suddenly everyone's debating whether the case is actually ready for examination the next. What makes Judge Simpson interesting here is that he mixes humor with very sharp procedural awareness. He may joke around, but he is absolutely tracking whether attorneys are properly prepared. And this next section exposes something viewers rarely think about. Courts hate wasted witness appearances. Prosecutors need witnesses ready. Defense attorneys may still be negotiating. Judges want efficiency. Everybody's operating on different timelines at once, and when those timelines collide, tension builds fast. Notice how the judge keeps pressing the issue of whether the parties are genuinely ready for a preliminary examination or still trying to negotiate behind the scenes. That matters because preliminary exams are resource-heavy proceedings. If attorneys request them without being prepared, the court sees it as unnecessary scheduling pressure. Also, the back and forth here reveals another truth about criminal court. Negotiations almost never stop. Even while dates are being scheduled, both sides are still calculating risk, leverage, and possible resolutions. That's why these hearings often feel less like clean legal procedures and more like high-pressure chess matches happening in public.
Well, is there any objection to that process from the people? Because your witnesses are going to be coming. I mean, I'm not.
Risk of being embarrassed. What resolution?
Oh,
Who did you talk to?
Judge,
that changes things.
here's the thing, Judge. Can we just set this for exam? If I will, if this court sets out a couple weeks, I will notify the prosecutor within a week if there's any resolution. Judge,
Oh, okay.
can we just set it for exam?
Mr. Brown, is that what you want?
Yes, please.
Okay, I'm gonna do. This is not the normal way we do it, but discovery is complete.
Yes, Your Honor.
Yes.
Would the people have their witnesses available on the 27th?
I believe so. Thank you.
I will be letting Judge Washington know that this matter should be going because they're not supposed to be set for exam unless you're ready to go. But it sounds to me like you're still trying to negotiate, which you should be doing at this stage.
Yes, Your Honor.
Preliminary examination will be set in person, February 27th, 2024, 9 a.m. before Judge Washington.
Thank you.
And continue.
Step your right.
Your name, sir?
Jacob, good now.
Thank you.
Your Honor, I'd be asking to adjourn the probable cause conference for 2 weeks and to very briefly address the issue of bond.
Probable cause conference, February 29th, 2024, 9 a.m. Yes, that's the bond.
Judge, well, when bond was set, he was held on a Wayne County matter. He's been sentenced to probation on that matter. He was sentenced yesterday. He's been in custody for 55 days. If he's released, he'll be staying at Lafayette Street address in Detroit with a friend of his. He'll be working at O'Brien Construction. He was on, his bond was revoked because he missed court.
Here we go again with another bond argument, and Judge Simpson is clearly hearing a familiar pattern. The defense is trying to present stability, housing arranged, employment lined up, probation status explained, transportation supposedly fixed. On paper, those are all the right things to say during a bond reconsideration. The problem is that credibility has already been damaged by previous failures to appear. That's the hidden theme running through this entire courtroom today: trust. Once a defendant misses court or ignores reporting requirements, every future explanation gets examined under a microscope, and Judge Simpson is absolutely not letting vague excuses slide. Transportation issues may sound understandable initially, but courts also expect defendants to treat appearances as mandatory obligations, not optional appointments. What's interesting is how the judge keeps circling back to behavior patterns instead of isolated incidents. He's not only looking at the missed appearance, he's looking at the community corrections failure too. That combination makes the court question reliability altogether. And viewers, be honest, do you think repeated transportation excuses should matter once someone already knows they're under court supervision? Or should the responsibility fall entirely on the defendant, no matter the circumstances? Because Judge Simpson sounds like he's already made up his mind long before the ruling officially arrives.
But he, like, as I indicated, he has been in custody now for almost 2 months. I believe that's a sufficient sanction for him missing court. This is a possession of a controlled substance charge. It is nonviolent. I'd ask the court to consider reinstating his bond, release him on a PR with whatever conditions the court believes are
Well,
appropriate.
not only did he do that, but he didn't report to community corrections either.
I had no transportation.
Pardon?
I didn't have any transportation at the time. It was transportation issues. That issue's not corrected.
Well, the problem is that back in March of 2023, he hadn't appeared, gave him an opportunity to report to community corrections. Told him he had to report that next day. If he didn't, then I would issue a bench warrant. He didn't appear at community corrections at all.
But he didn't, and as he indicated, Judge, he didn't have reliable transportation. He's addressed that issue. So if he's released now, he will be able to appear wherever the court orders him.
Well, then on his next date, he just didn't appear. How long was he in custody?
How long has he been in custody?
No, you said he was in custody someplace and that's why he wasn't here.
No, I didn't say. He's been in custody here for I think 56 or 57 days. He didn't appear because he didn't have transportation, is what he reported.
Where was he living?
In Detroit. I'm from Detroit. I'm on probation in Wayne County though. So
I mentioned that already. Thank you.
Yeah.
How'd you get picked up?
I was in Livonia and I knew I had
So somehow you got from Detroit to Livonia.
This is the exact moment the transportation argument completely collapses under scrutiny. Judge Simpson zeroes in on the contradiction instantly. The defendant says he couldn't make it to court because of transportation problems, but somehow managed to travel from Detroit to another location where he eventually got picked up. And once that inconsistency enters the record, the entire defense narrative starts looking shaky. This is why experienced judges ask follow-up questions that seem simple at first. They're testing logic, consistency, and accountability all at once. The court isn't just listening to the excuse, it's evaluating whether the excuse survives pressure. And honestly, the judge's reaction says everything. Short questions, sharp interruptions, minimal patience. When a judge starts reducing responses to quick factual checks instead of open discussion, it usually means the ruling is already leaning heavily in one direction. The defense attorney keeps trying to stabilize things by emphasizing probation, compliance, and future reliability, but the court appears focused on past conduct, not future promises. That's a difficult hole to climb out of in any bond hearing.
Yeah.
Just couldn't get here.
Well, it is farther, Judge.
Motion for bond reduction denied. Bond will continue. Thank you.
Thank you.
Court calls the case People versus Ezra Fleury.
On behalf of the people.
Mr. Flurry, on behalf of Mr. Flurry.
Mr. Killawall, are you standing in?
Good morning, Robert J. Kellogg. Your Honor, I'm standing for Marcia Kracher. My client has no objections to that. Per Marcia's instructions, she's asked for a 2-week adjournment. And Mr. Flurry does not object to that request.
Any response from the people? February 29, 2024, 9 a.m. bond continued. Thank you, sir.
Thank you, Your Honor.
Court calls the case of the people versus Eli Green.
Attorney Morgan Barosa on behalf of the people.
Morning, Assistant Public Defender Lauren Turney on behalf of Mr. Green. Mr. Green, can you state your name for the record, please?
Eli Green.
Your Honor, we are asking for an adjournment of the probable cause conference.
Without objection, February 29, 2024, 9 a.m. bond continued.
Your Honor, Mr. Green would like me to address bond.
Briefly,
He's asking for a 10% provision. If he were released, he would return to his home with his mother. He does have one child. He is working as at a temp agency and would be employed. And he indicated to me he does not have any prior convictions.
response from the people.
That is incorrect. He does have criminal adjudications, but he also has a pending matter in 14B that is up next on February 26th. My understanding, Your Honor, is that we originally requested $500,000 in this case, and we were issued a $25,000 bond. We are extremely concerned at the nature of this. The victim went to pick up the child during a child exchange, and the defendant pointed a firearm at her face and blocked it back. When officers were on the scene, the defendant struck his girlfriend, but said he struck his girlfriend, but denied using a gun. The officers tried to get the defendant to come out of the house with the child, and the defendant told officers he ran away from the scene and left the child alone in the house at the bottom of the stairs. He told the officers he wasn't coming back and to quote unquote come find me, bro.
This case just escalated dramatically. Up until now, we've mostly been dealing with missed court appearances, procedural scheduling, and bond disputes. But this hearing shifts into something much heavier: allegations involving firearms, domestic violence, a child present during the incident, resistance against officers, and even an alleged attempt to disarm law enforcement. And listen to how the prosecutor builds the narrative step by step. That's intentional. Prosecutors often stack details sequentially to increase the perceived danger level before bond discussions happen. By the time the judge hears about the child allegedly being left alone and officers allegedly being confronted while the defendant was holding that child, the courtroom atmosphere completely changes. Judge Simpson's reaction is especially telling because he openly questions why the bond was set so low in the first place. That is never a good sign for the defense. Once a judge starts suggesting prior bond conditions may have been too lenient, the odds of a bond increase shoot up fast.
The deputies entered the apartment to make sure the child was okay. They were alone, and the defendant was actually still in the apartment and came at the officers while he was holding the child. The defendant then assaulted Deputy Roberts by striking his heel into the face. The child was successfully taken away and given to a grandparent, but the defendant had tried to flee. He resisted multiple commands. He tried to disarm a police officer before he was finally taken into custody. At the time, I do think it's important to note that he did have the active domestic violence warrant out for his arrest from the 14B incident.
At the time that this occurred?
Correct.
And my understanding is that, I understand those are all allegations, but I also understand that there were injuries to 2 officers.
That is correct. Deputy Roberts and Sergeant Hogan.
And did it also during that altercation attempt to disarm the officer from his firearm? I don't know why this bond is set so low, quite frankly. Any response from the defense?
No response from me, Your Honor.
Court on its own motion is going to find that the bond that is set is an abuse of discretion. Bond is going to be increased to $75,000 cash surety.
Step to your right.
Your name, sir?
Jacob Goodenough.
Thank you.
Your Honor, I'd be asking to adjourn the probable cause conference for 2 weeks and to very briefly address the issue of bond.
Probable cause conference, February 29th, 2024, 9 a.m. Yes, that's the bond.
Judge, well, when bond was set, he was held on a Wayne County matter. He's been sentenced to probation on that matter. He was sentenced yesterday. He's been in custody for 55 days. If he's released, he'll be staying at Lafayette Street address in Detroit with a friend of his. He'll be working at O'Brien Construction. He was on, his bond was revoked because he missed court. But he, like, as I indicated, he has been in custody now for almost 2 months. I believe that's a sufficient sanction for him missing court. This is a possession of a controlled substance charge. It is nonviolent. I'd ask the court to consider reinstating his bond, release him on a PR with whatever conditions the court believes are
Well,
appropriate.
not only did he do that, but he didn't.
What's remarkable here is how we've circled back to another defense request built around the exact same strategy. Emphasize that the offense is nonviolent, stress the time already spent in custody, and argue that prior detention itself has been punishment enough. From a defense perspective, that's a logical approach. The attorney is basically saying, the defendant has already suffered consequences, so continued detention isn't necessary. But Judge Simpson keeps returning to one issue above everything else: compliance. The court seems far less interested in whether the charge itself is violent and far more focused on whether the defendant follows court orders consistently. Missing hearings, failing to report, and needing repeated explanations creates a credibility problem that keeps resurfacing case after case throughout this entire session. And there's another layer here people often miss. Judges are balancing risk every single time they rule on bond. They're asking themselves one core question: if released today, will this person actually come back? Once doubt enters that equation, bond reductions become incredibly hard to win. At this point in the hearing, you can already feel the courtroom pattern developing. Judge Simpson is rewarding preparation and accountability while punishing inconsistency almost immediately.
Report to community corrections either.
I had no transportation.
Pardon?
I didn't have any transportation at the time. It was transportation issues. That issue, correctly.
Well, the problem is that back in March of 2023, he hadn't appeared, gave him an opportunity to report to community corrections. Told him he had to report that next day. If he didn't, then I would issue a bench warrant. He didn't appear at community corrections at all.
But he didn't, and as he indicated, Judge, he didn't have reliable transportation. He's addressed that issue. So if he's released now, he will be able to appear wherever the court orders him.
Well, then on his next date, he just didn't appear. How long was he in custody?
How long has he been in custody?
No, you said he was in custody someplace and that's why he wasn't here.
No, I didn't say. He's been in custody here for I think 56 or 57 days. He didn't appear because he didn't have transportation, is what he reported.
Where was he living?
In Detroit. I'm from Detroit. I'm on probation in Wayne County though. So
I mentioned that already. Thank you.
Yeah.
How'd you get picked up?
I was in Livonia and I knew I had.
So somehow you got from Detroit to Livonia.
And here comes the exact contradiction Judge Simpson was waiting to expose again. The defendant keeps leaning on transportation problems as the explanation for failing to appear, but the judge immediately points out the obvious issue. Somehow transportation existed when it came to traveling elsewhere. That inconsistency is absolutely crushing for credibility. What makes this exchange so damaging is that Judge Simpson doesn't need a long speech. The short questioning style tells the story by itself. Judges often become more direct when they think the explanation no longer makes logical sense. Instead of debating hypotheticals, the court starts focusing on hard facts and contradictions. You can also hear the defense trying to recover by repeatedly emphasizing the defendant's custody time and future stability. But at this stage, the courtroom energy has shifted completely. The judge no longer seems interested in promises about what will happen moving forward. He's looking backward at what already happened, missed court, ignored reporting requirements, and explanations that keep unraveling under questioning. This is a brutal reminder that in criminal court, consistency matters almost as much as the underlying charge itself. Once the judge loses confidence in your reliability, every future request becomes harder to sell.
Yeah. Just couldn't get here.
Well, it is farther, Judge.
Motion for bond reduction denied. Bond will continue. Thank you.
Thank you.
Court calls the case People versus Ezra Fleury.
Children appearing on behalf of the people.
Mr. Flurry, on behalf of Mr. Flurry.
Mr. Killawall, are you standing in?
Good morning, Robert J. Kellogg. Your Honor, I'm standing for Marcia Krasher. My client has no objections to that. Per Marcia's instructions, she's asked for a 2-week adjournment, and Mr. Flurry does not object to that request.
Any response from the people? February 29, 2024, 9 a.m. bond continued. Thank you, sir.
Thank you, Your Honor.
Court calls the case of the People versus Eli Green.
Attorney Morgan Barroso on behalf of the people.
Morning, Assistant Public Defender Lauren Turney on behalf of Mr. Green. Mr. Green, can you state your name for the record, please?
Eli Green.
Your Honor, we are asking for an adjournment of the probable cause conference.
Without objection, February 29, 2024, 9 a.m. bond continued.
Your Honor, Mr. Green would like me to address bond.
Briefly.
He's asking for a 10% provision. If he were released, he would return to his home with his mother. He does have one child. He is working as at a temp agency and would be employed. And he indicated to me he does not have any prior convictions.
Response from the people.
That is incorrect. He does have criminal adjudications, but he also has a pending matter in 14B that is up next on February 26th.
This moment hits hard because it instantly undercuts the defense narrative in open court. The defense had just presented the defendant as someone without prior convictions, employed through a temp agency, connected to family, and potentially suitable for a reduced bond. Then the prosecution immediately steps in with incorrect. That single interruption changes the tone of the hearing fast. Now the courtroom is no longer just evaluating the current allegations, it's reevaluating credibility altogether. Prosecutors know that timing matters, and correcting the record right after a defense presentation can seriously damage momentum. It forces the judge to reconsider everything that was just argued moments earlier. Then the allegations themselves start stacking higher and higher. Firearm accusations, child endangerment concerns, assault allegations involving officers, resisting commands, attempted disarming of law enforcement, and suddenly this stops sounding like a standard bond discussion and starts sounding like a public safety argument. And viewers, this is where bond hearings become incredibly important. A lot of people think these hearings are minor procedural steps, but they can completely reshape a case before trial even begins. When a judge hears allegations involving violence, children, and officer injuries all in one sequence, bond conditions can escalate very quickly. That's exactly where this courtroom is headed now.
My understanding, Your Honor, is that we originally requested $500,000 in this case, and we were issued a $25,000 bond. We are extremely concerned at the nature of this. The victim went to pick up the child during a child exchange, and the defendant pointed a firearm at her face and clocked it back. When officers were on the scene, the defendant struck his girlfriend, but said he struck his girlfriend, but denied using a gun. The officers tried to get the defendant to come out of the house with the child, and the defendant told officers he ran away from the scene and left the child alone in the house at the bottom of the stairs. He told the officers he wasn't coming back and to quote unquote come find me, bro. The deputies entered the apartment to make sure the child was okay. They were alone, and the defendant was actually still in the apartment and came at the officers while he was holding the child. The defendant then assaulted Deputy Roberts by striking his heel into his face. The child was successfully taken away and given to a grandparent, but the defendant had tried to flee. He resisted multiple commands. He tried to disarm a police officer before he was finally taken into custody. At the time, I do think it's important to note that he did have the active domestic violence warrant out for his arrest from the 14D incident.
At the time that this occurred?
Correct.
And my understanding is that, I understand those are all allegations, but I also understand that there were injuries to two officers.
That is correct. Deputy Roberts and Sergeant Hogan.
And did it also during that altercation attempt to disarm the officer from his firearm? I don't know why this bond is set so low, quite frankly. Any response from the defense?
No response from me, Your Honor.
This is one of the strongest statements Judge Simpson has made all day, because the judge is openly signaling disagreement with a prior bond decision while the hearing is still unfolding. And once a judge says a bond amount may be an abuse of discretion, everybody in the courtroom knows the situation just became very serious for the defense. The prosecution laid out an extremely aggressive narrative leading into this moment. Allegations involving a firearm pointed during a child exchange, resistance against officers, injuries to law enforcement, and even an alleged attempt to disarm an officer while holding a child. Whether proven or not, those allegations dramatically affect how the court evaluates risk. What hurts the defense most here is the lack of pushback at the critical moment. Judge Simpson asks for a response, and there's essentially nothing substantial offered in return. Sometimes silence in court speaks louder than argument because it can suggest there simply isn't a strong counter available under the circumstances. Seconds later, the bond jumps to $75,000 cash surety. That's a major increase, and it sends a clear message. Judge Simpson believes the existing conditions were nowhere near strict enough based on the allegations presented. This courtroom has officially moved from procedural routine into full accountability mode.
Court on its own motion is going to find that the bond that is set is an abuse of discretion. Bond is going to be increased to $75,000 cash surety.
So our Assistant Public Defender with, and on behalf of Mr. Dibbles, who appears via Zoom.
Yes, sir.
Good morning,
Mr.
Judge.
Dibble,
Carrie
can you
Angie,
state your
appearing
name
on
for the
behalf of the Attorney General's office.
Thank you.
Mr. Dibbles, can you state your name for the record, please?
Yusef Dibbles.
Thank you, Your Honor. It is today's the date and time for a probable cause conference. It is my understanding that our office and the Attorney General here have come to an agreement where there will be a stipulation to change the bond to $20,000 at today's probable cause conference. And with that, we will waive the preliminary examination and ask for this matter to be bound over to circuit court for further resolution.
Now, this is a very different type of courtroom strategy. Instead of fighting aggressively at the preliminary examination stage, the defense and prosecution have reached an agreement involving bond modifications and a waiver of the preliminary exam altogether. That means the case skips directly forward into circuit court proceedings. For viewers unfamiliar with criminal procedure, waiving a preliminary exam does not automatically mean guilt. In many situations, it's a tactical decision. The defense may believe there's little benefit in contesting probable cause at this stage, especially if negotiations are already happening behind the scenes, or if there's a bond arrangement being secured simultaneously. What's especially interesting here is the financial structure surrounding the bond transfer. The court is discussing substantial money already tied up in another matter and redirecting those funds into this case. That tells you this defendant's legal situation is much larger than a single isolated hearing. But then the hearing suddenly shifts again when Kansas enters the conversation.
$20,000 cash.
Yes.
That's correct, Judge.
And Your Honor, if I may, his family is from Kansas. They're flying into Michigan today, hopefully to post that bond. So if
Judge, it's my
So
further
he does
understanding
reside
the
in
defendant. It's my further understanding, Judge, the defendant has agreed to immediately stipulate to transfer that $20,000 bond payment when it is made directly to the front of court account in this matter. Is that correct, counsel?
Yes, Your Honor.
All right, right. And typically that's what we do. So let's do the waiver first and then I'll deal with the bond. Mr. Dibble,
Yes,
you've heard what your counsel has indicated, that you're waiving your right to have a preliminary examination.
correct.
You
Yes, sir.
understand that, sir?
Yes,
You understand that a preliminary examination is a proceeding where the people would have to show by probable cause that the offense is alleged or the offense alleged was committed and that you committed it.
yes,
What happened?
You understand you won't have that hearing and that you'll proceed to circuit court for further resolution.
I was coming.
You understand that?
yes, sir.
All right. People also, for the record, waive their right.
Yes, Judge, thank you.
Preliminary examination having been waived, defendant's bound over on the single count. Counsel.
Your Honor, we acknowledge that information. We will waive formal reading of that and stand mute.
Defendant having waived formal reading, standing mute, court will enter a not guilty plea. Pretrial will be set for
February 26th at 1:30 before Judge Slay Monday.
February 26, 2024, 1:30 before Judge Slay Monday.
Thanks, Your Honor.
As to his bond, I will set the defendant's bond $20,000 cash. And that if the bond is posted, it's to be applied to circuit court case 200501 or 001, excuse me, 720 DM.
Thank you, Your Honor.
Thank you, Your Honor. He's allowed to go back to Kansas.
What?
He's allowed to go back home to Kansas. He was extradited.
Him and Dorothy.
You can actually hear the disbelief and tension building in this exchange. The defense is trying to frame Kansas as home, a place where the defendant has family support and stability. But the prosecution immediately shifts the focus back to practical reality: supervision, employment, bond monitoring, and the fact that Michigan already spent money extraditing him back to face these charges. And honestly, the prosecution raises a point judges care deeply about. Courts do not like uncertainty once a defendant is released. If someone leaves the state, who monitors compliance? Who ensures court appearances happen? Who enforces conditions if problems arise? Those questions matter enormously during bond decisions. Then Judge Simpson cuts through the debate with pure courtroom authority. The Dorothy comment injects humor for a split second, but underneath it is a very firm ruling. The defendant is not leaving Michigan, period. No ambiguity, no negotiation. And that's a classic Judge Simpson moment right there, humor wrapped around an absolutely rigid judicial line.
What do you mean?
Watch it.
That's who he needs to be with, sure.
So you're asking that?
Yeah, Your Honor. He lives in, he's planning to go back there right when he posts bond.
Okay, counsel, are you asking for permission to return to Kansas?
Yes.
Objection from the people?
Judge, I'm uncertain as to where the defendant plans to work, where he plans to live, who will supervise his bond conditions in the state of Kansas. This is the first that I've heard that he wants to leave the state and return back to Kansas. I do know that the state of Michigan paid $4,640 to extradite him here, to bring him back to take care of this responsibility, and that the arrears are in excess of $200,000 at this point. So I would certainly need to
Well,
know.
that's, I get it, counsel. I don't need anything else. Defendant must remain in the state of Michigan.
Oh my gosh.
Okay.
Understand? I am specifically not giving permission for him to leave the state of Michigan. He must remain in the state.
Understood, Your Honor.
And there it is, the final shutdown. Judge Simpson leaves absolutely no room for misunderstanding here. The defendant must remain in Michigan. No vague wording, no soft conditions. No, we'll revisit it later. The court wants total clarity on the record. This moment really summarizes the entire energy of today's courtroom session. Over and over again, Judge Simpson prioritized accountability, compliance, and risk management above emotional explanations or future promises. Whether it involved missed court appearances, revoked phone privileges, disputed transportation excuses, or bond increases, the pattern stayed consistent throughout every hearing. What's fascinating is how quickly credibility shaped outcomes today. Defendants who appeared inconsistent faced immediate skepticism. Prosecutors who brought detailed allegations gained momentum fast. And defense attorneys constantly had to fight uphill once trust issues entered the conversation. Courtrooms are unpredictable because every ruling depends on how judges interpret behavior in real time. Two defendants can make similar requests, but credibility, timing, preparation, and courtroom demeanor can completely alter the outcome.
Thank you.
Thank you, Your Honor.
Thank you.
What a courtroom session this turned out to be. From the opening moments, Judge Simpson made it crystal clear that this was going to be a day focused on accountability, courtroom discipline, and strict compliance with court orders. And by the end of these hearings, that message had been reinforced again and again through nearly every ruling we watched unfold. We saw phone privileges revoked after allegations of victim contact from jail. We saw bond reduction requests denied because excuses simply did not hold up under questioning. We saw transportation explanations fall apart once contradictions started surfacing. And perhaps most dramatically, we saw Judge Simpson sharply increase bond after hearing violent allegations involving firearms, officers, and a child caught in the middle of the chaos. One of the biggest takeaways from today is that credibility matters enormously in criminal court. Judges are constantly evaluating whether defendants are reliable, truthful, and likely to follow court orders moving forward. Once that trust weakens, even strong defense arguments can struggle to gain traction. And in the final moments, Judge Simpson's ruling, preventing the defendant from leaving Michigan, perfectly captured the court's overall mindset: control the risk, maintain jurisdiction, and ensure accountability stays firmly in place. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.